All right, good afternoon, everyone, and welcome. We have received the go-ahead to begin our trial from our bailiff, so we will proceed. This is the case of Marks versus Sonny's Rooftop Bar. My name is Jeffrey Harkavy. I'm a judge of the Los Angeles Superior Court and will be honored to preside over this round today. Scoring attorneys, thank you for closing out your cameras and muting yourselves. And they should remain off until we invite you to come back on for comments at the end of the round. The round is being recorded, so you'll have an opportunity at a later date, all participants, to watch it later. So I'm going to ask the plaintiff side of the case to please introduce themselves, starting with plaintiff's counsel, second chair, and witness, and then we'll follow the same with the defense. So plaintiff introductions, please.
Yes, Your Honor. Good afternoon. My name is Lillian Beatty, and I'll be counsel representing Ethel Marks, the plaintiff in today's case.
And do you have a second chair assisting you, Ms. Beatty?
Yes, Your Honor. May my second chair make introductions?
There she is. Yes, please go ahead.
Hi, my name is Madeline.
Okay.
I'm in the same room as the plaintiff attorney. My name is Madeline, and I will be the plaintiff's second chair.
Thank you. And plaintiff's witness, please.
Hi, I'm the plaintiff witness. My name is Jacinta Lopez, but I will be playing Morgan Levin.
Thank you. Introductions from the defense, starting with defense counsel, please.
Yes, Your Honor. Good afternoon. My name is Samyuktha Kumar. Today I am joined by my co-counsel and second chair, Radha Scotty.
Good afternoon, Your Honor.
Good afternoon.
As well as the party representative in this matter, Sunny Mehta.
Good afternoon. I am Sienna Claudio, but I will be playing Sony Mehta.
Thank you.
Today in this matter, we represent the defendant, Sunny's Rooftop Bar.
Thank you. Before we begin with the opening statements, are there any preliminary matters on behalf of first the plaintiff?
Yes, Your Honor. Just a few housekeeping matters. Your Honor, for clarification, as this trial is being conducted via Zoom, may we display exhibits via screen share constructively outside the view of the jury for purposes of identification?
Yes, you don't have to ask for permission. This applies equally to both sides. If you put up an exhibit, we are deemed at that moment constructively outside of the presence of the jurors, and so that it can be up on the screen for identification and any foundational questions before you seek to move it into evidence, if you seek to move it in.
Yes, Your Honor. And for clarification, the plaintiff would like to note for the record that the defense initially asserted 2 affirmative defenses. However, this court has dismissed the defendant's second affirmative defense, that of third-party contributory negligence in regards to Morgan Levin.
The court has read the pretrial rulings that were made before we assembled here today, and I'm aware of that motion in limine and that affirmative defense being stricken from the defense's answer in the case.
Yes, Your Honor. And finally, pursuant to evidentiary ruling 11, we would like this court to note that exhibits 1, 22, and 23 have been pre-admitted and may be used at any time throughout the course of today's trial.
Thank you, and that will apply equally to both sides.
Thank you, Your Honor. The plaintiff is ready to proceed at this time.
Thank you. Any preliminary matters on behalf of the defense?
Just a few, Your Honor. First, we'd like to clarify your position on publishing exhibits to the jury once they have been admitted.
Once they have been admitted, then they are free to be screen shared, and at that point, they will be deemed to be visible to the members of the jury at that point.
Would we need to ask Your Honor for permission to do so?
No. You can bring up the document without asking for permission ahead of time. Just identify what it is. That's exhibit 15, whatever the number may be, and bring it up right before you're going to be asking the witnesses questions about the exhibit. And if it is moved into evidence, and assuming that the court grants the motion to move it into evidence. At that point, either side is free to bring up the document at any time with an appropriate witness in the presence of the jurors. You don't have to ask for permission.
Yes, Your Honor. We'd also like to note that pursuant to Federal Rules of Evidence 615, all witnesses, with the exception of Party Representative Sunny Mehta, are considered constructively sequestered.
Agreed.
Nothing further from the defense, Your Honor. We are ready to proceed.
Thank you. We will now hear opening statements from each party. Everyone should make sure that they are in speaker view. That button is in the upper right-hand portion of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Plaintiff, you may proceed with your opening statement.
Thank you, Your Honor. And just for clarification, is everyone able to hear and see me clearly still?
From my standpoint, you are clear, both audio and visual, video are very clear.
All right, thank you, Your Honor. May it please the court. The defendant couldn't care less. Members of the jury, this is Jessica Marks. She was your typical college student. She enjoyed being with her friends, she worked hard, and she had a bright future ahead of her. That is, until that future was cut short in March of 2019, all because the defendant couldn't care less. Today, you'll learn that Jessica Marks was spending her spring break of freshman year in 2019 with her best friend, Morgan Levin. You'll learn that Jessica and Morgan went to a local place called Sunny's Rooftop Bar, and they chose this place for a reason, because it was an establishment known for not caring about the rules, a place where underage people were served alcohol. And on March 24th, 2019, that's exactly what happened. You'll learn that Jessica and Morgan ordered drinks, they talked, they laughed, and they had a good time. But unfortunately, their evening didn't end as well as it began, all because the defendant, Sunny's Rooftop Bar, just didn't care. In fact, members of the jury, today the defendant's carelessness extends to three specific factors in this case. First, the defendant didn't care. And so, of course, they didn't ensure that all of their patrons were over the age of 21. Second, the defendant didn't care. And so the bar owner, Sunny Mehta, can't show you her bartender's certifications because she never saw them, she never had them, she never even asked to see them. And Sunny's Rooftop Bar cared so little that they didn't hesitate for a moment while serving not only a minor, but an obviously intoxicated minor. Members of the jury, today the evidence will show that the defendant didn't care about age, they didn't care about authenticity, and they didn't care about the abuse of alcohol that occurred within their establishment. In fact, despite the fact that Jessica Marks was clearly exhibiting the symptoms of an obviously intoxicated person, they continued to take her order. They continued to serve her, and they watched silently as she exited their bar for what would be the last time. Because on March 24th, 2019, Jessica Marks crashed her car, not 2 minutes after leaving Sunny's. In today's case, we as the plaintiff have the burden of proof, and we will prove to you today by a preponderance of the evidence that the defendant is liable for the wrongful death of Jessica Marks by showing three things. First, that the defendant served alcohol to a minor, in this case, Jessica Marks. Second, that the defendant continued to serve alcohol to Jessica Marks while she was intoxicated. And finally, that the defendant's continual service of alcoholic beverages to Jessica Marks while she was obviously intoxicated is the proximate cause of her death. Now, members of the jury, the defendant will likely tell you today that Jessica Marks was completely sober. But you'll learn that before she knew she was being sued, the defendant, the owner of Sunny's Bar, told the police that she knew Jessica Marks wasn't sober, that she was buzzed at the least. And ultimately, at the end of this trial, you will learn that it's the defendant's actions that caused the death of Jessica Marks. because they clearly didn't care about age, about authenticity, about abuse, or about this young woman's life. And because they didn't care, Jessica Marks is no longer with us. And we ask you hold the defendant liable. Thank you.
Thank you, counsel. Defense, you may give your opening statement at this time.
Yes, Your Honor. May I proceed?
Yes, please.
Nothing to suspect, so nothing to stop. For Sunny Mehta, the night of March 24th, 2019 was like every other night. She was working at the bar she owned, Sunny's Rooftop Bar, where she was taking orders, delivering drinks, clearing tables, going up and down stairs, and interacting with every single person on the rooftop that night. For Sunny, nothing was out of the ordinary. But for Jessica Marks, the night of March 24th would be very different and far more tragic. That evening was her last in LA. She had arrived the week before to spend spring break with her best friend, Morgan Levin, but that trip was set to end the next morning. You will hear today that Jessica told her social media followers that she was going to go hard or go home. Jessica Marks was not ready to go home. So she and Morgan got into Jessica's car and drove the 25 minutes to Sunny's Rooftop Bar. What you will hear today is that Jessica and Morgan ordered alcoholic drinks. However, what you will not hear is how long Sunny Mehta, their server that evening, interacted with them, or what symptoms of intoxication he saw. Because you will hear nothing today that shows that Sunny Mehta ever saw Jessica displaying the signs you would expect from an obviously intoxicated person. Sunny Mehta was busy that evening. She had 12 to 14 customers to serve at once as the only server that evening. She was going up and down stairs, delivering drinks, taking orders, talking with every other customer. She did not have time to sit around and chat with Jessica Marks. California law requires that to find liability in this matter, that Sunny Mehta have served Jessica Marks alcohol when she was obviously intoxicated. Today, you will hear no facts can suggest to you that this occurred. When Sunny saw Jessica, there was nothing to suspect. So there was nothing to stop. However, there's another aspect to this case. What happened after Jessica left the bar was undoubtedly tragic. In a situation like this, it's natural to want to find someone to blame. After all, Jessica was just 19. She had her whole life ahead of her. As such, it's uncomfortable to ask ourselves if perhaps her unreasonable actions and conduct could have contributed to what happened. But the law says if that's the case, that is negligence. Jessica Marks was the one who made the decisions that evening. She refused to follow the advice of her best friend and the law. Jessica drove while she was intoxicated, and that is what killed her. Those decisions were Jessica's, and not the ones of Sunny's Rooftop Bar. Sunny Mehta had nothing to suspect, so there was nothing to stop. It was Jessica Marks who chose to drink, and it was Jessica Marks who chose to drive while intoxicated. It's for all of these reasons that I will return at the end of this trial and ask for the only just verdict consistent with what actually happened on March 24th, 2019. A verdict of not liable. Thank you.
Thank you to both counsel. Before the plaintiff calls its first witness, I will ask everyone to switch to gallery view, again in the upper right-hand portion. That will allow you to see the attorneys and witnesses at the same time. The plaintiff may now call their first witness.
Yes, Your Honor. Today, the plaintiff calls Morgan Levin to the stand. Your Honor, may I proceed?
Yes, please.
Good afternoon, Ms. Levin. Would you please introduce yourself to the jury?
Good morning. My name is Morgan Levin.
And Ms. Levin, do you know why you're here today?
Yes. My best friend, Jessica Marks, she's not with us anymore.
And Ms. Levin, when was the last time you saw Jessica?
Right as she got into her car, right as she got into her car, she was driving home, right before it fell into the ravine.
Now, Ms. Levin, before we discuss the events that occurred on March 24th, I want to give you a chance to introduce Jessica to the members of the jury. What was she like?
She was outgoing, much more than I. She loved to dance and sing. She was a happy person.
And did you grow up together?
Yeah, I knew her since middle school. We were best friends ever since we met.
Did you end up going to the same college after you graduated high school?
No, we wanted to, but she went to Drexel and I went to LA.
And did you ever happen to see each other while you were in college?
Yes, we stayed in touch. So we saw each other on winter break and on spring break.
Now, Ms. Levin, I know this will be difficult for you, but I do need to talk about the week of March 24th, that spring break in 2019. Did you and Ms. Levin had any plans for that week?
Yeah, we were planning on hanging out, going to some bars and restaurants. We were gonna go to Disney World.
And I know this may seem obvious, but was it your plan to order alcohol at any of these establishments?
Yes, it
Objection,
was.
Your Honor, relevance.
Okay, could you repeat the objection?
Objection, Your Honor, relevance.
Counsel?
Yes, Your Honor. If I may, this testimony is extremely relevant as it goes to prove Ms. Marks and Ms. Levin's intent to order alcohol, which directly establishes why we're here in court today and the events that led up to her death.
Your Honor, may I be heard?
Yes.
Your Honor, that would apply only to the events of March 24th, 2019, not to any other event that week. If that's being applied as the case, we would raise an objection to improper character evidence.
Any response by plaintiff?
Yes, Your Honor. Specifically, this is relevant evidence as it is foundational to the testimony in regards to the fact that Ms. Levin and Ms. Marks were planning on ordering alcohol. And furthermore, character evidence is admissible if it goes to prove motive, intent, or plan, which this directly does.
Your Honor, may I be heard?
I'm going to sustain the objection only as to the event outside, let's say within a day or so of March 24th. Beyond that, the other activities have very marginal relevance, but certainly as to the events of that day, or if it's important, maybe a day before, something along those lines, or the day after, what the plans were going to be for the following day, those have relevance. So I'll sustain the objection in part, but overrule it in part, and she can talk about the events in or around March 24th.
A motion to strike the answer not relating to the days surrounding March 24th.
Motion to strike just those portions is granted, and the jury is instructed to disregard.
Yes, Your Honor. May I proceed with questioning?
Yes, please.
All right. Now, Ms. Levin, specifically in regards to March 24th, did you and Jessica have any plan to order alcohol?
Yes, we were gonna go to Sunny's rooftop bar.
And how were you and Ms. Marks obtaining alcohol if you were under the age of 21?
Jess had gotten me an early 21st birthday present. She called it, she'd gotten me a fake ID.
Objection, Your Honor, relevance.
Your Honor, may I be heard?
Yes.
Your Honor, the manner in which Ms. Marks and Ms. Levin were able to obtain alcohol on the 24th is relevant as it goes to establish the foundation for the reason, again, why we're here in court today.
Your Honor, may I be heard?
Yes.
Your Honor, this is a case of strict liability, meaning it doesn't matter whether or not Sunny Maida knew that Jessica Marks was a minor at the time she served her alcohol. Thus, the matter of fake IDs is not relevant and in fact could serve to mislead the jury under 403.
How do you respond to the strict liability argument that it is not an element that the plaintiff must prove to establish your case? You do not have to prove that the defendant knew that the persons they were serving were minors. And if that's the case, well, how is the false ID information relevant?
Of course, Your Honor. Specifically in regards to opposing counsel's objection of that this is a case of strict liability, we would agree that this is a case of questioning the liability of each party. However, as the plaintiff, we do believe that the matter of fake IDs is extremely relevant and does go directly to that issue. Because in laying the foundation that these IDs were not checked, we're also laying the foundation that the defendant should be liable because they didn't take the steps necessary to prevent Ms. Marks from not only ordering alcohol, but becoming obviously intoxicated, continually serving, and eventually leading to her death.
So is it the plaintiff's position that the IDs were not checked by the defense?
Yes, Your Honor.
Okay, then I don't see what the relevance of them having the fake IDs would have if they were never seen, checked, or taken into consideration by the defense just because they had them. I don't see what the relevance would be. So I'm going to sustain the objection on grounds of relevancy.
Motion to strike, Your Honor.
Motion to strike to the extent the answer was given is granted, jury's instructed to disregard.
Yes, Your Honor. May I proceed with questioning?
Yes, please.
Now, Ms. Levin, I do want to talk about the evening of March 24th. Around what time did you first see Jessica that night?
Probably around 6. She came to pick me up at where I was staying, and we went to her Airbnb.
And did you ever leave her Airbnb during that night?
Yes. We decided to go to Sunny's rooftop bar that night.
And when you arrived at Sunny's, did Jessica seem intoxicated to you?
Just as we arrived up, she started seeming a little buzzed. She smelled like alcohol and she started getting louder.
And when you and Jessica entered Sunny's, did anyone stop you or ask you for identification?
No.
And was this what you had expected?
Some of my friends had told me Sunny's didn't card.
Objection, Your Honor, hearsay.
Okay, let me let the witness finish the answer first, and then I'll hear the objection. Go ahead.
Some of my friends told me Sunny's didn't card, but I've never been there before, so I didn't know.
Okay, the objection is hearsay as to what the friends had told her. How does the plaintiff's counsel respond?
Yes, Your Honor. This testimony, specifically under Rule 803.21, is in regards to a reputation in a community concerning character, specifically concerning the character of Sunny's bar, and is therefore admissible hearsay.
Your Honor, may I be heard?
Yes, go ahead.
I'd like to further object to a lack of foundation. Plaintiff counsel has not established when or where Morgan heard these statements.
All right, I'll overrule the objection on the on hearsay, and I'll sustain it on the grounds of character as to that it's not clear the time frame of when that information was received, but counsel can follow up on that.
Yes, Your Honor. And just to be clear, Ms. Levin, when did your friends tell you this? Was it recent?
Yeah, I guess so. At school, people would go to bars, and so it was just common knowledge that Sunny's rooftop bar didn't card. Like I said, I'd never been there before I went with Jess.
And so at any point during that night, did you ever show your real or fake identification to Sunny Maida or any of her employees?
No, I didn't. They didn't ask for it.
While you were at Sunny's, what drinks did you have?
I had a glass of wine, a beer, and a shot.
And could you recall for us what Jessica had?
Yes, Jess had the rest of the bottle of the wine. She had a beer too, 3 White Claws, and she also had a shot.
And while you were at the bar that night, did you happen to take any videos of Jessica?
Yes, I took one for her Insta.
And would you recognize this video if I showed it to you today?
I would.
Your Honor, let the record reflect that I'm now displaying Exhibit 10. Apologies for the feedback, Your Honor.
Yes, don't see it yet, but
Yes, Your Honor, we're now just. Now, Ms. Levin, are you able to see that on your screen?
Yes.
All right. And do you recognize this exhibit?
Yes, that's the video I took for Jess's Insta.
Does it appear to be a fair and accurate reflection of the video that you recorded from that night?
It looks like it.
All right. Your Honor, at this time, we would now move to admit Exhibit 10 into evidence.
any
Objection, Your Honor, relevance.
Your Honor, if I may be heard.
Yes.
Your Honor, this video specifically shows the actions of Jessica Marks taken that night. It's a recording of the way that she was acting. And as this is a question of obvious intoxication, any evidence that goes to prove whether she was or was not obviously intoxicated is extremely relevant and goes directly to the issue.
I would agree with that. I need to see the video though to see all we're seeing right now is what looks like a photograph. Can't even tell. It's
Your
a
Honor,
video.
may I be heard?
Yes.
Your Honor, the plaintiff counsel has provided no evidence that the defendant, Sunny Mehta, ever saw this conduct or was present when this video was taken. The question presented before us is specifically whether or not Sunny Mehta saw Jessica's conduct and proceeded to serve her anyway. Until plaintiff counsel provides that foundation or evidence, this is not relevant.
Well, let's take it one step at a time. Since you're moving the video into evidence, I need to see the entire video. I take it it's not very long, correct?
Yes, Your Honor, we can play that video.
All right, let's go ahead and play the video. We're still
Hi, everyone.
The court is ruling on the motion to the objection to it being received.
Yes, Your Honor, we'll now play the entire video.
Hi, everyone. Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Your Honor, we would now move to admit Exhibit 10 into evidence.
All right. And defense has made their objections. The foundation's been laid as to when this was taken, who took it, that it's an accurate depiction, and that as to whether this specific conduct was seen or not, or whether it was indicative of any conduct that may have been seen by the defense, goes to the weight versus admissibility. So that will be for the jury to determine and counsel to argue that the objection is overruled and the video is received in evidence.
Yes, Your Honor.
Thank you, Your Honor. May I proceed with questioning?
Yes, please.
Yes, Your Honor. Now, Ms. Levin, how would you describe Jessica's behavior at Sunny's bar that night?
She started seeming drunk as we kept being served on more drinks. She stumbled a couple times. She stopped making sense and her eyes kind of got bloodshot and watery that night.
Towards the end of that evening, do you recall talking to anyone besides Jessica?
Yes, we talked to Sunny Mehta. She was our server that night.
Do you remember what Sunny said to you, if anything?
At one point, Jess stumbled into Sunny, and Sunny said, "We might need to cut this one off."
And was anything else said to you that night?
Yes, right before we were served the green tea shots, she pointed at Jessica and said, "I hope this one's not driving."
After the defendant said we might need to cut this one off, did Sunny or any of her staff continue serving you that night?
Yes, they kept serving us drinks.
At any point during the night, I want to be completely clear, Miss Levin, did Sunny Maida or any of her employees refuse to serve you drinks?
No, they didn't.
And did Sunny or any of her employees attempt to prevent Jessica from drinking?
Council time has stopped.
Yes, Your Honor. No further questions.
Thank you.
Cross-examination, Your Honor.
Yes, please.
May I proceed?
Yes, please.
Ms. Levin, I want to focus on how March 24th, 2019 began. You went to Jessica's Airbnb?
Yes, we were at her Airbnb for a while.
At that Airbnb, you two had some alcohol. Is that correct?
Yes, I had like a glass of wine and Jess had like one or two.
When Jessica was at the Airbnb, she made a social media video. Is that correct?
Yeah, I think so.
In that video, Jessica said she was going to go hard or go home.
I think so.
Jessica then said that she was not ready to go home.
Objection, Your Honor, to relevance.
Your Honor, may I be heard?
Yes.
These statements establish Jessica's state of mind at the time that she was at her Airbnb, which would go to her intent to drive while intoxicated, which is evidently negligent.
Counsel.
Your Honor, any statements as well as evidence from Ms. Marks and Ms. Levin being at Jessica's Airbnb is irrelevant, as it has nothing to do with what actually occurred later in the night.
I'm going to overrule the objection. I think it has some relevance as to her state of mind and what she may or may not have had planned for that evening, and how those plans may have affected her actions and behavior later in the evening. I believe it has sufficient relevance to make it admissible. I'm going to overrule the objection. The witness may answer the question.
Ms. Levin, Jessica said that she was not ready to go home.
Yeah, she said that.
She was holding a glass of wine when she said that.
Yes, from what I remember, she was drinking wine at her Airbnb.
The two of you left Jessica's Airbnb at around 8:30. Does that sound right?
Yes.
The two of you were going to a bar?
Yes, we were going to go to Sunny's rooftop bar.
Your intent that evening was to drink alcohol, correct?
Yes.
Knowing that Jessica got behind the wheel?
Yes.
After she had drank alcohol?
Yeah, after she had the glass of wine, she drove us to the bar.
Okay. I now want to discuss later in that evening, when you got to Sunny's rooftop bar. When you got there, you began to order alcoholic beverages?
Yes.
You maintain that you were just buzzed that evening. Is that correct?
Yeah, I was a little bit buzzed that evening. I'd had a shot, a beer, and a glass of wine.
All of those drinks were alcoholic?
Yes.
Let's discuss how you got those drinks. Sunny Maida was your server that evening?
Yes, he served all of Jess's and I's drinks.
Sunny came to your table, you'd say between 8 to 10 times?
Yeah, around 8 to 10 times.
These interactions were not full-on conversations. Is that correct?
No, not while he was serving our drinks. It was like a minute each.
Right, it was 30 to 60 seconds.
Yeah, around.
Now, Miss Levin, you cannot point to a time where Jessica had bloodshot eyes in front of Sunny.
I guess not specifically. The whole night, she kind of had red and watery eyes.
Thank you for that answer. Directing you back to my question, you cannot point to a time where Jessica had red eyes in front of Sunny, yes or no?
I guess I can't point to a specific time.
You also cannot point to a specific time where Jessica slurred her words in front of Sunny, yes or no?
Not a specific time.
Nor can you point to a specific time where Jessica did not make sense in front of Sunny, yes or no?
Yes, I can't point to a specific time either. She was just acting that way the whole night.
So that's a yes to a no to my question. You can't point to a specific time?
Yes, I can't point to a specific time.
You can't testify either to the fact that Sunny Maida was on the rooftop when you took Exhibit 10?
No, I can't be sure.
I'd like to focus on later that evening, when you left Sunny's rooftop bar. You maintain that you were still buzzed?
Yeah.
So you were not drunk?
No, I was just buzzed.
But you had problems walking to your Uber that night. Isn't that right?
No, Jess had.
Is there an objection?
Yes, Your Honor. Relevance as to this witness's conduct?
Your Honor, may I be heard?
Yes.
If I may make an offer of proof?
Yes.
I was about to introduce Exhibit 26, specifically page 7, lines 6 through 8. Those lines are from an unavailable witness, Mr. Stevie Reger, who also saw Morgan Levin's conduct that evening. However, Mr. Reger found that Morgan did have problems walking to her Uber, so this would call Ms. Levin's credibility into question, and credibility is always relevant to the jury.
Well, she hasn't answered the question yet. The question was whether or not she was having difficulty walking to the Uber. Is that correct?
Yes, Your Honor.
Okay. What's your offer of proof as to what you expect this witness will say in response to your question?
Your Honor, I expect that the witness will testify that they did not have problems, at which point I would introduce the unavailable witness's testimony.
Okay. I'm going to overrule the objection. The witness's state of intoxication, sobriety is relevant on the ability to remember accurately and accurately perceive the events of that evening, and even to remember accurately the events of that evening. So evidence of impairment, such as difficulty in walking in the parking lot or wherever, has relevance on that issue, and goes to credibility of the witness's ability to remember and accurately remember and perceive what was occurring. So I'll overrule the objection. The witness may answer the question.
Yes, Your Honor.
I didn't have problems walking. Jess did. She was struggling to walk.
Thank you for that answer. Directing you back to my question, you had problems walking to the Uber. Is that right?
No, again, that wasn't me. That was Jess.
Your Honor, defense moves to introduce Exhibit 26, page 7, lines 6 through 8. This is testimony from an unavailable witness, Mr. Stevie Reger, who saw Morgan Levin's conduct that evening.
Objection, Your Honor. May I be heard?
Yes. So let me hear the objection to the introduction of this statement. Yes.
Yes, Your Honor. We believe that the introduction of Stevie Reger's deposition is not only an improper opinion, but there's also a lack of foundation as to this witness, who this witness is, how they were there, how they knew any of these events that occurred. And it's also much more prejudicial than probative.
Your Honor, may I be heard?
Yes.
This evidence has significant probative value. Mr. Stevie Rieger was another patron of the bar that evening who saw Morgan Levin's conduct. This testimony directly contradicts what you just heard Ms. Levin testify to, which would raise issues of Ms. Levin's credibility to the jury.
Well, so as to the objection of lack of foundation, are there other parts of the Rieger deposition that established that Stevie Rieger was present and observed, was precipient to the events that are testified to in the deposition?
Yes, Your Honor. I'm not aware of the exact lines. However, the deposition does contain that foundation.
Okay, let me ask Ms. Beatty, do you agree that the deposition, Stevie Rieger's deposition, establishes that Stevie Rieger was there at outside of the rooftop bar on the night in question?
Your Honor, while it may establish that, may I be heard?
Yes.
Your Honor, specifically, while this may at one point throughout this deposition establish that Stevie Rieger was at the bar that night, there's also the issue in regards to this testimony that opposing counsel won't be reading any of that foundation, and as far as we're concerned, is only attempting to enter and read this specific portion of the deposition, which would be misleading to the jury.
So if the rest of the deposition were to be, or at least the part of the deposition that establishes foundation were to also be entered in, you would not have that objection, correct?
Not that objection specifically, Your Honor.
Okay. So you realize that would potentially open the door to the rest of Stevie Rieger's deposition coming in?
I apologize, Your Honor. We wouldn't have that specific objection to foundation in regards to that issue. However, we would still object to this being an improper opinion, as well as the fact that there's no opportunity for us to question this witness. This witness is unavailable to testify, and therefore we are not able to get any more information out of this witness, which again would be misleading to the jury if we entered it today.
I'm going to overrule the objection. This was a deposition, so both sides had an opportunity to direct and cross-examine this witness. The statement was made under oath, as it always is in depositions. And it's not an improper opinion. It says her friend could barely walk in a straight line to the Uber. That's an observation, not an opinion. So I'm going to overrule the objection on all grounds stated. And this witness is an unavailable declarant, but was available to be questioned by both sides during the deposition. So the motion to admit this portion, Exhibit 26, is granted over objection.
Yes,
Your Honor. Ms. Levin, I'm going to read you a few statements. Please pay attention as I'm going to question you about them in a moment. Question: were you concerned about Jessica getting behind the wheel? Answer: she was in better shape than her friend. Her friend could barely walk in a straight line to the Uber. Ms. Levin, you understood that?
Your Honor, I would object specifically within this deposition to the line "she was in better shape than her friend" to speculation.
Well, I'm going to sustain that portion of the better shape than her friend. It's vague, and the purpose of this appears to be impeachment. That this witness says that she was not impaired, or that it wasn't this witness's inability to walk the straight line to the Uber. It was Jessica Marks, the decedent. So you may question about that one line starting with her friends and ending with the word Uber only.
Yes, Your Honor.
Thank you, Your Honor.
So, Ms. Levin, you were not able to walk to your Uber in a straight line?
No, I was. It was Jess who couldn't walk in a straight line.
Let's focus now on Jessica's behavior that evening. Jessica did not drive home with you?
No, she decided to get into an Uber. I couldn't stop her.
Did you meant that she decided to drive her car home?
Yeah, she did. She seemed so drunk, so I asked her to get into the Uber with me, but she went home on her own.
Right. She insisted that she would be fine.
Yeah, but I should have stopped her. She wasn't fine.
Jessica said that she was pretty good at driving after a big night.
Yeah, she did.
Let's now focus on what happened after Jessica's accident. You were the one who called 911?
Yeah, that was the first thing I did. I called 911 and I tried to find Jess's body.
You spoke to the investigating officer at the scene?
Yes.
Bringing up Exhibit 23, which has already been admitted into evidence.
Yes.
Ms. Levin, you lied to that investigating officer. Is that correct?
I didn't want to get Jess or I in trouble.
So that's a yes, you did lie?
Objection, Your Honor, to relevance.
Okay, time has been called, so the witness will not have time to answer the question. So I don't have to take up the objection. So there's no further time for cross-examination, and counsel, you used all of your direct examination time, so there's no opportunity for redirect of this witness. Any further witnesses or evidence on behalf of the plaintiff?
No, Your Honor. At this time, the plaintiff rests our case in chief, and we would ask this witness be excused.
Thank you. Witness may step down and is excused. Plaintiff having rested, defense, you may call your witness.
At this time, the defense calls Sunny Maida to the stand.
Yes.
May I proceed?
Yes, please.
Miss Maida, what did you do for a living back in 2019?
I used to be the owner of Sunny's Rooftop Bar.
When you owned Sunny's Rooftop Bar, what was the layout like?
Well, the bottom floor had the counter in the bar where the bartender would usually work in the restroom, but most of the customers spent time upstairs, and that's where they preferred to enjoy their meals and drinks.
Did you have to get any training to own your bar?
Yes, you have to be certified to run a bar.
Did that certification cover signs of intoxication?
Yes, it did. All of my employees had to be certified.
If you saw someone who was displaying those signs of intoxication, what are you supposed to do?
Well, I'm supposed to immediately cut them off and not serve them any more drinks.
I'd now like to focus on March 24th, 2019. Were you working at your bar that evening?
Yes, I was.
Was anyone else working?
Yes, me and a bartender, Frankfurt, were both working that night. So there was only two of us, so we were handling everything that had to do with the bar that night.
How many customers did you two have?
Overall, throughout the entire night, there was about 20 customers, but only 12 to 14 at a time.
Was one of those customers someone named Jessica Marks?
Yes.
What time did you first see Jessica?
I first saw Jessica Marks at around 9 p.m.
Was she with anyone?
Yes, she was with a girl named Morgan Levin.
When you saw Jessica at 9 p.m., what did she look like?
Well, she's short, 5 foot, but she seemed sober to me.
What happened after that?
Well, I served her some drinks.
How many times did you serve her drinks?
I went over to their table around 8 to 10 times and served them various drinks and food.
How long did you go over there?
Only for about 30 seconds to a minute. I was kind of bouncing around tables that night.
When you went and saw Jessica, what did she look like?
She seemed pretty sober to me. There was no signs of intoxication at all.
You mentioned earlier that you were the only server that evening. What was your job like?
Well, first I would take the orders of the customers. Then I would go downstairs to the counter and tell Frankfurt or who was the bartender that night, what the orders were. I would wait for him to get the orders prepared. Then I would bring them back upstairs and serve other tables, maybe clear off some tables if I see some empty drinks.
Opposing counsel mentioned earlier an incident where Jessica stumbled into you. Did that ever happen?
No, that did not happen.
Ms. Levin then testified that you said something about cutting Jessica off. Did that ever happen?
No, absolutely not.
So let's go over what did happen. When you saw Jessica, were her eyes ever bloodshot?
No, I did not see that.
Were her eyes ever watery or vacant?
No.
How did Jessica's speech sound?
She sounded pretty good to me. She spoke and ordered with complete fluency, so.
Jessica, did she ever lose control over coordination?
No.
And I'd like to focus on Jessica's companion that evening, Morgan Levin. What would you say her behavior was like?
Well, she seemed a little buzzed, slurring her words here and there, but other than that, she seemed okay.
What time did both Jessica and Morgan leave your bar?
I would say they left at around 11:45.
When they left, what was Jessica's behavior like?
Well, Jessica seemed fine. I didn't suspect anything, so.
What about Morgan Levin's behavior?
Morgan seemed a little buzzed, but she was okay as well.
I want to be clear, Ms. Maida. At any point that evening, did you ever suspect that Jessica might be intoxicated?
No, absolutely not. I didn't see anything that would point towards that.
So at any point in that evening, did you ever think you needed to stop serving?
No, there was nothing to suspect, so there was nothing to stop.
No further questions at this time. Thank you, Ms. Maida.
Thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, please.
Good afternoon, Ms. Maida. Before we discuss the events of March 24th, I want to talk about some of the procedures that your bar follows. You've owned Sunny since February of 2017, correct?
Yes.
And you're aware of all of the certifications and procedures that a bar has to have in California, is that right?
Yes.
You would consider yourself to be a responsible bar owner, wouldn't you?
Yes, I would.
And you would also consider your employees to be responsible, is that right?
Yes.
Now, you claim that all of your employees completed the responsible beverage service course and passed the exam. Is that true?
Yes, they told me so. I made sure to ask.
But to be clear, you can't provide any documentation to back this up, can you?
Your Honor, relevance?
Your Honor, may I be heard?
Yes.
This specifically goes to attack this character's credibility, as well as the idea that this witness would be a responsible business owner, as she has claimed previously.
Your Honor, may I be heard?
Yes.
It was established on direct that the majority of these employees were not even present on March 24th, 2019, and as such, their conduct has very little relevance to today's case.
Well, she testified about her being a responsible business owner, or given that impression, and that all employees must be certified, and that the requirement that all people who are working in the bar be certified. And if the testimony should be that there's no verification of these certifications, that has relevancy. I'm going to overrule the objection.
Yes, Your Honor.
Now, I'll go ahead and re-ask that question. You don't have any proof. You can't back up that claim that all of your employees are certified, correct?
No, but I trust my employees.
Well, you don't even have a copy of these certificates on file, right?
No, I do not, but I asked them to make sure, and I trust my employees.
Well, but just to be clear, you never even asked to see those certificates, did you?
No, but once again, I believed my employees when they directly told me that they were certified.
Right, you say you believed your employees, and that would extend to Frankfurt Johnson, right?
Yes, I trusted Frankfurt.
Well, In fact, you trusted Frankfurt Johnson enough to continue employing him after he pled guilty to serving a minor in 2018. Isn't that true?
Well, I don't
Objection,
think,
Your Honor. Relevance?
Counsel?
Your Honor, if I may be heard.
Yes.
Specifically, this line of questioning, as well as this witness's testimony, continues to go back to that idea of her being a responsible business owner, attacking her credibility, as well as the fact that she did not have responsible business practices as she is claimed.
Any response by the defense?
Your Honor, opposing counsel has not provided any evidence that Frankfurt Johnson served Jessica Marks that evening or was involved with the events of March 24th, 2019. And we maintain that the actions of employees outside that night are not relevant to this case.
Your Honor, if I may be heard.
Yes.
Your Honor, regardless of whether or not Frankfurt Johnson did or did not serve alcohol to Ms. Marks on that evening, he was still someone who Sunny Maida saw fit to employ continually, even after he was cited for serving a minor, which would be relevant in today's case because it continues to attack this witness's credibility.
Your Honor, may I be heard?
I'm going to overrule the objection. I believe there's sufficient relevancy to the witness is maintaining that she runs her business consistent with law, consistent with good practices, and okay, one moment.
Apologies, Your Honor. I think I lost connection for a second
Yeah, we
there.
lost connection for just a moment. I'm overruling the objection. The witness is testifying that she trusts her employees, and this potentially impeaches the witness in far as whether she is using proper judgment in employing and trusting an employee who's had assuming this employee had a past violations that's specifically relevant to this charge, which is serving a minor, in this case, serving obviously intoxicated minor. I believe it has sufficient relevancy for impeachment, and this is cross-examination. So I will overrule the objection. The witness will be, if the attorney hasn't finished the question, you may finish the question, and then the witness is instructed to answer.
Yes, Your Honor. Would it be all right with the court if I repeated the question for clarification?
Certainly.
Thank you, Your Honor. I'll go ahead and ask that question again, Ms. Maida. In 2018, Frankfurt Johnson pled guilty, and you still saw it fit to continue employing him following that incident. Is that right?
yes, but I believe he did not know that that was a minor at all.
But directing you back to my question, you still saw it fit to employ him following his service of a minor.
Yes, because he believed that that was not a minor and he was fined, and we implemented new services to better check IDs.
Well, just to be clear, after this incident, specifically the one in question, during the first week of June of 2019, Frankfurt disappeared, didn't he?
Yes,
And to this day, you don't know where he is, correct?
Objection, Your Honor. Relevance?
Counsel, what's the relevance?
Yes, Your Honor. Specifically, this line of questioning is going to attack specifically Frankfurt Johnson, as well as showing that he did know, and this witness continued to keep him on as a server.
I'm going to sustain the objection as to the employee's actions after the day in question. I don't believe that those subsequent actions are relevant. I'll sustain that objection.
Motion
Yes,
to strike, Your Honor.
If the witness answered that question or gave a partial answer, that answer to the extent it was given is stricken, and the jury will be instructed in this disregard.
Yes, Your Honor.
Yes, Your Honor. May I proceed?
Yes.
Thank you. Let's go ahead and move on and talk about the events that occurred on March 24th. Ms. Maida, you claim to be the only person that served Jessica Marks and Morgan Levin that night. Is that true?
yes, I was the only person.
And you stated in your deposition that you were sure you had checked Jessica and Morgan's IDs that night. Is that right?
Yes, I was sure.
However, when you were deposed, you were able to identify both IDs as being fake within a few seconds. Is that true?
Yes,
Now, assuming that you did check Jessica and Morgan's IDs that night, you would have known they were fake, right?
possibly, but yes.
Well, is it your testimony that you don't know how to check if an ID is fake?
Well, as I just said, yes, I do know how to check if an ID is fake. And I said, possibly because I don't really know what the circumstances were during that night. But yes, I do know how to check an ID.
All right, but just to be clear, you served Jessica Marks alcohol that night, true?
Yes, I did.
And you served Morgan Levin.
Yes, I did.
You let them order multiple drinks, right?
Yes.
And they sat at your bar for hours.
Yes, I think they sat at my bar for about 2 hours.
Now, to be clear, it's your testimony today that Jessica Marks was never obviously intoxicated, right?
Yes, that is correct.
But you did say that Morgan Levin was never obviously intoxicated either.
Well, no, she wasn't obviously intoxicated, but she did seem a little buzzed.
Well, you told us that Jessica wasn't exhibiting any symptoms after drinking that night, right?
No, she was not.
But Morgan was.
Yes, a couple of symptoms, but nothing too major.
And to be clear, they were both ordering drinks the entire night.
Yes, both of them were ordering drinks together.
But you told us that Jessica wasn't exhibiting any symptoms after drinking.
No, there was nothing to suspect.
But you thought Morgan was buzzed.
A little.
And you never cut her off.
No, I'm not supposed to cut off people who are buzzed. I'm supposed to cut off people who are obviously intoxicated.
Now, I want to talk for a second about why that is specifically. You make money based on how much a person orders. Is that true?
Yes.
And so the longer someone stays at Sunny's, the more they order, the more money you make.
Yes.
You would agree that you brought Miss Levin and Miss Marks their check that night, right?
Yes, I did.
The total was $119.
Yes, but I don't get all of that money. A lot of the money goes to refunding for the money I paid for the alcohol, really.
Oh, but just going back to my question, their total for that night was $119, correct?
Yes, but once again, not all of that money came to the bar. A lot of it was for refunding the drinks that we paid for.
And Miss Levin tipped $20, right?
Yes.
But she wrote her total down as $149, which is $10 more than what she had tipped. Is that right?
Yes, she did.
And you never told her this, did you?
No, I do not remember telling her this.
I want to be completely clear today, Miss Maida. At no point during the evening of March 24th, 2019, did you refuse to serve Jessica Marks, right?
No, there was nothing to stop.
And at no point did you ever attempt to prevent Jessica Marks from driving home?
No, she seemed fine.
In fact, you didn't offer to provide any form of alternate transportation, as you say is regular practice at your business.
No, I didn't need to. There were other times where I did need to, but in this case, I didn't need to.
But that's a no to my question. You didn't offer any form of alternate transportation?
Yes, no, I did not need to.
And at no point did you ever attempt to prevent Jessica or Morgan from drinking, did you?
No, there was no need.
Your Honor, I have no further questions.
Thank you. Any redirect examination?
Yes, Your Honor, one moment. Ms. Maida, opposing counsel just asked you a lot of questions about the employees at your bar. Did you believe that they were all certified?
Yes.
They also asked you about your own conduct. I want to be clear. If you saw someone displaying signs of obvious intoxication, what would you do?
Yes, I would cut them off immediately. You know, I interact with my customers at my bar, and if I would have seen someone, I would have cut them off.
At any point on March 24th, 2019, did you feel the need to do so with Jessica Marks?
No, I never suspected anything or saw any signs of obvious intoxication that night. So there was nothing there to cut off.
No further questions, Your Honor. Thank you, Ms. Maida.
Thank you. The witness is excused. Any further witnesses or evidence on behalf of the defense?
Not at this time, Your Honor. In fact, the defense rests.
Thank you. Would either defense or plaintiff like a short break before closing argument? If not, we can proceed directly. But if either side or both sides want a 5-minute break, we can take a break.
Your Honor, we'd be ready to proceed whenever.
We are ready to proceed now as well.
Very well. Thank you. Plaintiff will now present their closing arguments. Everyone should now switch back to speaker view. Since all the witnesses have completed their testimony, scores, you can go ahead and complete the witness portion of your ballot. And we will now hear from plaintiff on closing argument. And please advise the court at some point in time if you wish to reserve any of your time for rebuttal. Plaintiff may proceed.
Yes. Thank you, Your Honor. And with that, we would like to reserve any time remaining for a rebuttal.
Thank you.
May it please the court. The defendant couldn't care less. Members of the jury, we've seen today that because the defendant was careless with who they employed, careless with who they served, and careless with how much they served, Jessica Marks is no longer with us. The defendant's owner, you heard in the testimony of Morgan Levin, admitted that she hoped this one wasn't driving home, that they might need to cut this one off. The defendant may have hoped that Jessica Marks wasn't driving home, but she did nothing to ensure that she wouldn't. In fact, you heard today that the defendant did absolutely nothing to ensure that an obviously intoxicated young girl would not be driving home. The defendant didn't care enough to call an Uber or a taxi or a cab for Miss Marks. The defendant didn't care enough to ensure that she wouldn't drive. And because of that carelessness, Jessica Marks crashed her car not 2 minutes after leaving Sonny's bar. We've seen that the defendant clearly didn't care about Miss Marks, but let's talk for a minute about what she did care about. Well, first, the defendant cared enough about bringing in business that she was either willing to overlook a fake ID or not check it at all. Second, the defendant cared enough about profit that she let Miss Marks and Miss Levin continue to order drinks. She let them sit there for close to 2.5 hours. And the defendant cared enough about profit from that night that she neglected to inform Miss Levin that she added an extra $10 onto her tip from that night. Today, you heard testimony from Morgan Levin that before they even walked into Sonny's bar, Jessica Marks was beginning to exhibit symptoms of someone who was buzzed. And you've heard today that Jessica Marks was not sober, not when she was away from the bar, not when she entered the bar, not when she was at the bar, not when she left the bar. She was never sober. And today it's undisputed that the defendant served alcoholic beverages to Jessica Marks, who was a minor at the time. Both parties agree on this fact. So today, members of the jury, it's your job to focus on that second and third issue. First, the issue of obvious intoxication, and second, the issue of proximate cause. And today, through testimony, we've proven to you that the defendant continued to serve Jessica Marks alcohol past a point of obvious intoxication, and that continual service was the proximate cause of her death. Members of the jury, let's talk about that first point. You heard today, by the testimony of Morgan Levin, that a 5-foot-tall, 115-pound young girl had 3 hard seltzers, a shot, a beer, and the rest of a bottle of wine that only had 1 glass out of it at the time. And you also heard that she was never sober. Now I want to address what the defendant has said today and what the defense has offered to you, because the defense has said that there was nothing to suspect, and so there was nothing to stop. But members of the jury, this simply isn't true. They claim that there was nothing to suspect. But are we not going to consider the bloodshot eyes? The fact that she smelled of alcohol, the obviously fake ID, the slurred speech, the stumbling, her loud talking, and the fact that she didn't make sense. Members of the jury, you watched Exhibit 10 today. The defense expects you to believe that because she held the keys in her hand, because she made the decision to drive, that Jessica Marks should be held responsible for her actions. But members of the jury, the defendant made much more than just one decision. Sunny Meda overlooked the fake ID. Sunny Meda took the orders. Sunny Meda carried the drinks to the table. Sunny Meda served an obviously intoxicated young girl, and Sunny Meda watched silently as that young girl exited their bar. And the defense also expects you to believe that although someone who was buzzed, Jessica Marks's best friend, she didn't think she was safe to drive. But the bar owner, who hadn't had a drop of alcohol that night, didn't notice any of those signs, that she didn't see the bloodshot eyes, that she didn't see the intoxication. Members of the jury, this simply isn't true. And it's because we've proven to you by a preponderance of the evidence that the defendant continued to serve, continued to take the order, and looked an obviously intoxicated young girl in the eyes as she left, that we ask you hold them liable for her wrongful death, and that we ask you find them liable at the end of today's trial. Thank you.
Your Honor, I believe you're muted.
I certainly was. Thank you. Thank you to plaintiff's counsel. Defense counsel, you may give your closing argument at this time.
Yes, Your Honor. Nothing to suspect, nothing to stop. On March 24th, 2019, Jessica Marks walked into Sunny's rooftop bar. When she arrived, she ordered a round of alcoholic drinks, and then another round, and another, and another. Every time she ordered, Sunny Meda came to her table. Those were brief interactions, no more than 30 seconds to a minute. And in those brief interactions, Sunny Meda saw nothing. All of the facts she had at the time pointed to a Jessica that was not obviously intoxicated. You heard today that in the times they interacted, Jessica's eyes were not bloodshot, watery, or vacant. She was not slurring her words. She was not overly loud. She was making perfect sense, and she sounded sober. Sunny Meda is someone trained by the state of California to recognize signs of intoxication, to know what they are, and to know what to do. You heard today that at no point in that evening did Sunny Meda ever suspect that Jessica was obviously intoxicated. If Sunny had seen anything that would suggest that was the case, she would have done what she was trained to do. She would have stopped serving. But at no point in that evening did she ever suspect that that would be necessary. You heard today that Sunny Meda was the only server present on March 24th. As such, she had a lot of responsibility. For every customer present on the rooftop that night, which was between 12 to 14 at one time, she would have to be the one to get their drinks. More specifically, she would have to be the one to first go to their table, take an order, answer any questions they had, go downstairs to the bar, talk with the bartender, wait for that bartender to make the drink, because there was only one bartender. Then, after that time was over, come back upstairs, deliver the drink, clear away an empty glass, and start again. And again, and again, and again, because Sunny Meda was unquestionably busy. So she did not have time to spend 3 or 4 hours interacting with Jessica Marks. Members of the jury, the plaintiff has put before you things that Sunny Meda did not see, observations that never happened, other things that Sunny Meda could not have reasonably known. Keep in mind, these interactions were just 30 to 60 seconds. As Ms. Levin said herself, these were not full-on conversations. They were just Sunny doing what she needed to do and then leaving the table. That's all that happened. 8 to 10 times, less than a minute. It's not reasonable to expect Sunny Mehta to put together an opinion on Jessica's level of intoxication, considering things like Exhibit 10 or Morgan Levin's testimony as to what Jessica was behaving like. Sunny Mehta could only consider what she knew. And what she knew pointed to a Jessica that was not obviously intoxicated. Members of the jury, Miss Beatty would like you to believe that Morgan Levin's testimony, especially about Exhibit 10, is incredibly reliable. That's not the case. You saw Exhibit 23 in court today, the police report of what happened at the accident. It's also in front of you. That report details what Morgan Levin said at the scene of the crash. And in that report, Morgan Levin lied again and again. She told that officer they had had no drinks, then that they'd had a few drinks. But you heard Miss Levin's testimony today. In that testimony, she claimed Jessica had had 3 White Claw hard seltzers, a shot, and some other alcohol. Members of the jury, that is not 3 drinks. And that is, in fact, 3 lies, one after another after another. Morgan Levin also doesn't remember what happened that night. You heard she can't point to a time where Jessica ever slurred her words or had bloodshot eyes while Sunny was present. You also heard that Morgan Levin could not remember her own behavior. She said she did not stumble in the parking lot, that she could walk in a straight line. And then you saw Exhibit 26. You saw another instance where Miss Levin was wrong. Miss Levin's testimony that Exhibit 10 was representative or about any of Jessica's conduct that evening is not reliable. As such, there is no evidence that shows by a preponderance of the evidence that Sunny Mehta ever served Jessica Marks alcohol when she was obviously intoxicated. That is the standard you must consider. However, there's another aspect. Jessica Marks was just 19. In a time like this, it is uncomfortable and unpleasant to sift through the details of her life, to ask ourselves if her death could have been her own fault. But the law says that if your unreasonable conduct contributes to your own death, that is negligence. On March 24th, Jessica Marks made a decision before she even arrived at Sunny's rooftop bar. She said she was going to go hard or go home. Then she drank some alcohol and she got in her car and she drove while intoxicated before Sunny Mehta ever saw her. Then she drove again when she was leaving the bar, despite how much she drank, despite the fact Morgan Levin told her not to, despite the fact that that was not a reasonable decision. She drove. That is what contributed to her death, the decision to drive under the influence. The facts of this case result in a sad and uncomfortable conclusion. Jessica Marks was the one who made the decisions. She drank and then she drove. The sad truth presented before us today is that it was Jessica Marks' decisions that were the ones that caused her death. Sunny Mehta had nothing to suspect, so there was nothing to stop. For all of these reasons, we respectfully ask for the only just verdict, a verdict of not liable. Thank you.
Thank you, counsel. Plaintiff, you may give your rebuttal.
Thank you, Your Honor. May it please the court. The defense has just stood before you and told you that because there was nothing to suspect, there was nothing for Sunny Mehta to stop. And today, they asked Morgan Levin if she could point to any time when, in front of Sunny Mehta, Jessica Marks was acting intoxicated. But I want you to think back to the direct examination, where she specifically stated that Jessica's demeanor for that entire night was consistent with what you saw in that video. That the things that she was doing and saying were consistent. So maybe she can't point to one time, but she can point to the entire night, because that's how Jessica Marks was acting. I want you to think back to exhibit number 10, that 30-second long video. It was uncomfortable to watch. So now imagine watching that 16 to 20 times. That's about 8 to 10 minutes, which comprises the time that Sunny Maida was interacting with Jessica and Morgan. She had to have known. She had to have seen, but she just didn't care. And finally, in regards to the police report, Sunny Maida also lied when she told the police that Jessica Marks was a buzzed girl, but now she's claiming she's not intoxicated at all, but completely sober. So we ask you find them liable. Thank you.
Thank you very much, counsel. That concludes the statements, evidence, and closing arguments of all counsel. At this time, I'm going to ask our scorers to please